let us just quickly look at what should be our approach on the drafting part. We have seen that for a situation-based question, it is very clear that you need to read the question multiple number of times, understand the scope of the question, and look at the concluding part of the question. Because in the first part of the question, they may give you a set of factual situation, but in the concluding part, they are going to ask you. So we need to structure our answer based on what is being asked. Bear in mind, you have very little time once you read the question and once you create your answer. Always be to the point, though you may want to say many things, try to confine your answer to the question that is being raised. If the question says mention the provision, at least give the provisions. If you don't know, roughly you remember 54 to 56 deals with patent of addition. But you really don't know which provision actually tells you that there is no need for paying the renewal fee for a patent of addition. You don't know that. So you can broadly mention, if you're not able to recollect the particular section or the particular subsection, then you can broadly mention that patents of additions are covered by sections 54 to 56. That should do you good. I've been asked these questions many times. What if we don't know that particular section? Then if you know that, that's why if you group the sections together, if you know that the chapter 6 is on anticipation and chapter 6 runs from section 29 to 33. You don't know which provision talks about exhibition, anticipation and exhibition. That is section 31, sorry. You don't know which provision talks about public working, which is section 32. And you don't remember which provision talks about publication without consent. That is section 29. Still, if you don't remember the details, you can still broadly mention at the top of your answer that chapter 6 deals with anticipation, which runs from section 29 to 34. Okay, so that is something which you can anyway do. Even if you don't know the particular provision or the subsection, still make an attempt to cover a broad statement of the sections that are relevant. Because that's something which we repeatedly saw, that they keep asking that in the questions. You have to mention the provision of law and see how the provision of law is applicable. With regard to the situation-based questions, you are fairly clear that you will have to read the question well, understand what is being asked, and then try to create your answer with the legal provisions and enumerating the details in the legal provision. Most likely, you may have to write a concluding part in your answer as well. In a situation-based question, if the question says that, how will you advise the client? Then you have to say, I will advise the client not to file the patent, or to file the patent, or not to, to oppose it or to amend it, whatever your advice is going to be. So this is the structure. You first introduce the facts that are relevant, map it with the provisions, and say what is the, analyze it, and then come to a conclusion. So we had already discussed the IRAC method. So keep that as a guiding principle for answering the situation-based questions.